Alright, let's go at Standard 13, Substandard C. Describe the rise of Jim Crow, Plessy v. Ferguson, and the emergence of the NAACP. Alright, we talked about the rise of Jim Crow before, but not in great detail. We talked about the election of 1876, the Compromise of 1877 that brought an end to Reconstruction, and we said part of the agreement, whether it was an agreement or not, was that the southern states would have troops removed and it would end Reconstruction. As soon as President Rutherford B. Hayes did that, we talked about how southern states started passing black codes, segregation laws. You know, the KKK had come up then, and it's going to resurface later on during this time period. But they started passing laws to keep African Americans from voting. The poll tax was a southern law to keep African Americans from voting, to charge them money. We talked about the literacy test, where you had to take a test, and we said that the poll tax and the literacy test kept white people from voting, so they'd come up with a grandfather clause. If your grandfather voted, you could vote too. Not many African Americans' grandparents had voted, so that would give white people a chance. But when we talk about the rise of Jim Crow, what develops in the South after the Freedmen's Bureau pulls out, and after Reconstruction shuts down and the military zones are shut down and the military pulls out, is the advent of a series of laws called, or we refer to today as Jim Crow laws. They were actually called segregation laws, or separation of the races laws. In the 1870s and 1880s, in various southern states, took away the civil rights of African Americans, especially the right to vote. We talked about that just then. But it also separates public facilities and says that white people and black people cannot drink out of the same water fountain, or go to the same swimming pool, or be served in restaurants together, or in schools for that matter. So segregation laws is the separation of humans into racial groups in daily life. It may apply to activities such as eating in a restaurant, drinking from a water fountain, using a public toilet, attending school, going to the movies, or in the rental or purchase of a home. Characteristics of this, they had black and white water fountains. You just saw a picture of that. White's only fountain and a black's only fountain. And there were all black and all white schools, because some laws required, especially in Georgia in 1872, all schools are to be segregated. Violating schools who violated this will not receive money for public school fund, and we're going to look at that a little closer in a minute. Let's see. Examples are blacks had to move to the back of the bus to allow white people to sit up front. So part of this segregation was segregated buses, and here's a picture of a segregated bus during this time period with the white people sitting in here. It didn't mean that black people couldn't sit up front. It just meant when white people got on the bus, black people had to move back to the back of the bus. And there was a sign that said colored seated in the rear. And African Americans were required by law to give up their seats to whites and move to the back of the bus if they got on the bus. So that was segregated busing. And blacks could not eat in white restaurants. In Georgia, segregation or Jim Crow laws require that all persons licensed to conduct a restaurant shall serve either white people exclusively, that means exclude blacks, or colored people exclusively, that means exclude colored people, and shall not sell to the two races within the same room or serve the two races anywhere under the same license. That's a Georgia statute there. And here's a colored dining room here. Only black people could be served food in here. No whites could be served in here. Blacks exclusively. And so these segregation laws are splitting blacks and whites up so they can't be together. Non-example is Brown versus Board of Education, 1954. We're going to get that in Unit 9. It's going to overturn the Plessy case we're about to talk about. The name Jim Crow is pretty equivalent to segregation. And Jim Crow refers to a minstrel character. These minstrel books and songs. My name is Jim Crow. I jumped Jim Crow's a little song created back in the 1830s, 1880s, 1820s, 1830s, and this character come about called Jim Crow. And white people would dress up like African Americans and jump around the stage, and their face would be painted white, black, but around their eyes and mouth would be white. And they would act like black people and talk like, "Hello, massa, how's you?" And it brought out stereotypical understandings of African Americans. And it's unknown how the term got associated with what we're studying now, racial segregation and discrimination in the South. But that is exactly what the term became used to depict, is this idea of Jim Crow South or segregated South discrimination in the southern part of the United States in the first half of the 20th century. And so Jim Crow becomes social and legal laws that were meant to separate the races in society. So when we say Jim Crow, we actually mean also segregation laws. Jim Crow laws or segregation laws are the same thing. They're both meant to separate the races in society. Same examples here. Here's the Jim Crow era, separate public facilities. Segregation is equivalent to saying Jim Crow laws, segregation laws, same thing. Here's a segregated water fountain. The whites only, colored only. Swimming pool. Here's a restaurant. Here's a picture of a young boy drinking out of a colored only water fountain. And we looked at this restaurant here in Georgia. Schools were segregated. Notice that there's no white children within the schoolroom. In the state of Georgia, $43 per white student was spent on education in 1930. But Georgia only spent $10 on each black student in the state of Georgia in public education. Significant difference. The education was not equivalent. White schools would replace their books every, I think, 7 years, and African American children would get books up to 20 years old from the government. So it was really not an equal education, but they had separate schools, separate facilities for blacks and whites. Even here in Decatur County and in Bainbridge, the Hutto Middle School used to be an all-black high school. And 11th grade, it says here, was added in 1928. 12th grade was added at Hutto in 1953, and it wasn't mixed in with the high school and white kids until 1970, and we'll talk about that later on. We'll talk about Brown versus Board of Education. But Hutto High School used to be an all-black high school until 1970. And even the hospital, Bainbridge Hospital, was for whites exclusively, whites only. And this was by law, by Georgia law. Doctors could only serve African Americans if there were white doctors. This comes from the December 23rd, 1920 edition of the Bainbridge Searchlight, Post Searchlight. It says, "For whites exclusively, corner of West and Evans Street, the Bainbridge Hospital." And here's one in 1917 that didn't necessarily say for whites exclusively, was probably obvious, but Dr. Kish's non-surgical hospital was open for even poor patients. I just put this in here to show you they were at least trying to help poor people. I don't know if that meant black, I doubt it. But 1 hour devoted daily to free consultation for the city poor from 1 o'clock p.m. to 2 o'clock p.m. on the side entrance. It may have not have, but corner of Clay and Planter Streets in Bainbridge. But this one here shows that that blacks were excluded from the Bainbridge Hospital in 1920. Alright, and here's the bus here again. We're going to revisit this when we talk about Montgomery bus boycott, and we'll talk about that in Unit 9, but we'll come back and refer to this then. Alright, let's turn to Plessy versus Ferguson. We said we had to learn about that. Segregated trains. In Louisiana in 1890, a law was passed as a segregation law or Jim Crow law that said these little cars here, we talked about these in the Pullman Palace Car Company. This is probably one of those. And there was a separate one for blacks. Probably wasn't as delicate and in good shape. But anyway, the law required that all railroads operating in the state of Louisiana provide equal but separate accommodations for white and African American passengers, and prohibited passengers from entering accommodations other than those which they had been assigned on the basis of their race. So they had a black car like this and a white car, whites only, whites exclusively, or blacks exclusively. And that was the Louisiana law in 1890. In 1892, an octoroon, by the language of the time, this guy here is 1/8 black. It means he's 7/8 white, and they refer to them as an octoroon. But his name was Homer Plessy, and on June 7th, 1892, he bought a first-class ticket for the commuter train that ran from New Orleans, Louisiana to Covington, Louisiana. And he sat down in the car for white riders only, and the conductor asked him whether he was a colored man or a white man. He said yes, he was a black man, and he was sitting in the whites only, exclusively white section, so he was arrested by the train people. He was supported by a group in New Orleans, and they called and they knew he was going to be on there, and they told him so he could be arrested so they can change the law. But Homer Plessy is going to challenge this law, this 1890 Louisiana separate car law. And as his challenge, he's going to use the 14th Amendment we talked about that was ratified during Reconstruction, the Reconstruction Amendments. And this last one down here mandated that all citizens be guaranteed equal protection of the law, and it restricted states like Louisiana from denying those citizens life, liberty, property without due process of law. And he was challenging this equality clause here, saying that all citizens had to be guaranteed equal protection of the law. And we said that that 14th Amendment was going to lay the groundwork for future civil rights movements in the 1960s, but here it's being used in an attempt by Homer Plessy to say that he was being treated unequally in violation of the 14th Amendment. And in 1896, the case went to the Supreme Court, and the Supreme Court in Homer and Plessy versus Ferguson, 1896, establishes a doctrine that we call separate but equal. And you need to remember this, it's very important. The separate but equal doctrine here. Extremely important. And it ruled that it was not unconstitutional for states like Louisiana to separate the races as long as they had equal services. As long as they have equal services is what it said. And so segregation or separation in public places became legal. And this case is going to cause the rapid escalation of Jim Crow laws across the South, or what we call segregation laws across the South, because the Supreme Court said to separate the races or segregate the races was perfectly constitutional and legal. And here's how they reasoned this. Okay, let's take the train incident here with Homer. They said, okay, we have a cart here for white folks and we have a car here for black folks. Are both cars on the train providing an equal service? Are blacks and whites being taken from point A to point B, or from point B to point A? And they said yes, they are. So the reasoning was that both races were traveling equally from equal places, getting the same travel or service from the government, but they were just doing it in different cars. So they reasoned it did not violate the 14th Amendment equality doctrine. All it did was require separation of the races. If we were to use the water fountain in the separate but equal doctrine, here's what they would say. Are black people getting water from the government? Yes, they are. Are white people getting water from the government? Yes, they are. So they're both getting water as a public service. Therefore, it is an equal service. It does not violate the 14th Amendment. So the reasoning was that both races were supplied drinking water equally, just in different fountains, so that there was no violation of the 14th Amendment. We're going to see in Brown versus Board of Education in 1954 that this will be challenged. Okay. Alright, the next thing we have to talk about is the emergence of the NAACP. The NAACP emerges in the different thoughts of Booker T. Washington an African American leader, and that of W.E.B. Du Bois. Booker T. Washington come up with the Atlanta Compromise, in which he urged black people to avoid in order to get economic self-improvement, make something of yourself, that you needed to avoid political agitation for equality or integration or justice, in return that whites would guarantee due process of law for blacks, and they would give money to educate black people and build black schools. So he said, don't agitate the social status quo to get equality and integration into the community, because that's going to stir up too much social dissent. Alright, this guy here, W.E.B. Du Bois, wrote a book called The Souls of Black Folk in 1903. He's going to repudiate Washington's accommodationist philosophy. He's going to say that's no good. That's just no. We don't need to do that, because that's just accommodating white people. And he called for full political, economic, social, and political, economic, and social equality for African Americans. 100% civil rights for African Americans. Total equality. So he believes in agitating for social equality and integrating, having justice. And so in 1905, W.E.B. Du Bois formed what's called the Niagara Movement to resist the Jim Crow laws that were being passed during this segregationist period. And it was W.E.B. Du Bois in 1908, after the failure of the Niagara Movement to pick up or generate any public support or financial support, Du Bois met with a number of white and black reformers and created or founded the National Association for the Advancement of Colored People. And the NAACP, as it became known as, its main goal was to fight against racial segregation or Jim Crow laws, and fight for full political, economic, and social equality for African Americans. In other words, full civil rights for African Americans. Not accommodationist, but 100% equal rights for African Americans in the United States. Okay? Alright, so have we met our objective here? Was to describe the rise of Jim Crow, Plessy v. Ferguson in 1896, and the emergence of the NAACP. I think we have. Watch the video over again, raise your hand in class, ask questions. Good luck on the quiz, test, and the EOCT. Military pulls out is the advent of a series of laws called, or we refer to today as, Jim Crow laws. They were actually called segregation laws, or separation of the races laws. In the 1870s and 1880s, in various southern states, took away the civil rights of African Americans, especially the right to vote. We talked about that just then. But all right, let's get standard 13, substandard C. Describe the rise of Jim Crow, Plessy v. Ferguson, and the emergence of the NAACP. Alright, we talked about the rise of Jim Crow before, but not in great detail. We talked about the election of 1876. The Compromise of 1870, the poll tax and the literacy test kept white people from voting, so they come up with a grandfather clause. If your grandfather voted, you could vote too. Not many African Americans' grandparents had voted, so that would give white people a chance. But when we talk about the rise of Jim Crow, what develops in the South after the Freedmen's Bureau pulls out, and after Reconstruction shuts down and the military zones are shut down in the mills, you know, the KKK had come up then, and it's going to resurface later on during this time period. But they started passing laws to keep African Americans from voting. The poll tax was a southern law to keep African Americans from voting, to charge them money. We talked about the literacy test, where you had to take a test. And we said that in 1977 that brought an end to Reconstruction, and we said part of the agreement, whether it was an agreement or not, was that the southern states would have troops removed and it would end Reconstruction. As soon as President Rutherford B. Hayes did that, we talked about how southern states started passing black codes, or more, excuse me, segregation